What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. It's been a while. I realize I've been busy, but we are back with another episode talking about a boxer that actually won a jury verdict against his promoter, and he used the Ali Act as a result, received a jury award of over $1 million. Now, that jury verdict is being contested by the promoter in post-trial briefing, but let's talk a little bit about the lawsuit and the jury trial and then tell you where it's going right now. A jury in an Iowa federal court found in favor of Canadian heavyweight boxing star Mladen Miljas. The Canadian heavyweight filed a lawsuit against his promoter Greg Cohen, and a jury back in February found Cohen and his promotional company liable for breach of contract, violations of the Ali Act, fraudulent inducement, and tortious interference with business relationships for the boxer. To give you some context to the lawsuit, Miljas was an up-and-coming heavyweight boxer that was signed by Greg Cohen with the promise that he would help him elevate his career by getting him the necessary matchups to become a heavyweight champion. That did not come to pass according to Miljas' lawsuit, which he believed that Cohen did not provide him with the necessary fighters to propel him up to the top to become a champion. As a result, he notified Cohen that Cohen and his promotional company had breached the contract with him in the fact that a couple things. The details of the promotional contract indicated that he was entitled to 3 fights a year. In the first 2 years of that contract, he only had received 2 fights a year, and noted that the people that he was set up against would not help his career. They were quote unquote tomato cans. So he filed this, he indicated in a notice of potential breach, which was in the contract. It stated that there was a right for a person that is about to breach to notify the non-breaching party about a potential breach, and that would in effect notify the non-breaching party of this grievance and a potential ability to rectify the grievance prior to any further dispute occurring. And this is things like this are utilized in contracts all the time. A lot of these contracts occur like in the service industry or where there's a sale of products. There's a duty to cure, which is usually the legal term used by many lawyers, and basically it allows a certain period of time, I believe it was either 20 or 30 days, for the person to be on notice, non-breaching party, to be on notice of what's going on, of the breaching party, of what's going on, and to cure this issue. Well, in fact, Cohen did not cure the issue. It sent a letter indicating that they had not, the Cohen Promotions had not breached the contract. So another added thing to this lawsuit, which relates to the Ali Act claim, was that Cohen, according to Miljas, had him hire a manager. A new manager, not one that Miljas had independently found, but hire a manager to represent him. And that manager, according to the lawsuit by Miljas, had a previous relationship with business relationship with Cohen. So he did not know that until later on, and that became part of the lawsuit. So Miljas claimed that Cohen had materially misrepresented to him that he could guide his career and provide him quality fights. Cohen had indicated in the response to the notification of a breach sent by Miljas that the pandemic was one of the reasons why they could not schedule as many fights as possible according to the terms of the contract. So impossibility, the defense of impossibility was claimed by Cohen. Now, the other defense Cohen had was that Miljas, who had been training in the United States, moved back to his native Canada. And that created another layer of issue for setting up a fight for Miljas. There was a fight that Cohen had set up with a bigger heavyweight, and Miljas wanted extra time to train for this bigger heavyweight, but it was not afforded to him, and therefore Miljas declined the fight. And Cohen used that fact as a defense to his claim that Cohen was not providing enough fights and enough quality fights for him to succeed in his career. So Miljas terminated the promotional contract. There's a breach. Cohen did countersue. This went to all the way through a trial, and the jury found in favor of Miljas. And now the total amount that was handed out by the jury was $567,441.75 for Greg Cohen Promotions. Now, Greg Cohen individually also had to pay an amount, and the total amount of that was $825,732.75. That's a whole lot of money. That's over $1 million that had to be paid out by Craig Cohen. Now, as you might assume, with this hefty judgment against the promoter, Cohen filed what's called a motion for judgment notwithstanding the verdict, or judgment as a matter of law. Judgment as a matter of law. So they brought this up during the trial, according to court papers, and that was denied, and they are renewing the judgment as a matter of law. So basically, what a motion for judgment as a matter of law states is that the law is clear that the person. Let me back up. A judgment a matter of law indicates that despite the jury verdict, the jury has ruled against the standing law that was applied before the court. So basically a misapplication of the law. And so one of the things that Cohen was stating was that he should not be individually handed a judgment as a result of the alleged allegations of the lawsuit. So he was personally handed a judgment, and his promotional company, his LLC, was handed a judgment. So Cohen is claiming that there's no individual liability because Cohen was acting on behalf of his company as promoter. He didn't do something outside of the scope of his duties as a promoter in relation to this lawsuit. So there's that argument. The other argument is that he did not, he being Miljas, and his attorneys did not bring evidence supporting their Ollie Act claim, meaning that they didn't show how he was harmed, and they therefore the Ollie Act does not apply. So that one is a little more legalistic as far as the Ollie Act goes. The claim, a couple of claims are made related to the Ollie Act. The first one was that Miljas was never shown the amounts given. I mean, Miljas was never shown the amounts that were earned by Cohen as promoter pursuant to the Ali Act. The Ali Act requires that the boxer has a right to see what the promoter is making from off of the event featuring the boxer. So Miljas claims that that was never provided to him. And also, as I alluded to in the earlier part, that a manager who had a previous business relationship with Cohen was required to be managing Miljas at the time that Cohen was promoting Miljas. Now that one you could see would be a little bit more of semantics there, because you could argue that the manager and promoter, even though they had a previous business relationship, did not have a current business relationship. So there is no violation of the Ali Act per se, although you can infer that the two were possibly working in tandem as a team, manager and promoter. And as we know, the Ali Act prevents that from happening, a firewall, if you will, to prevent a manager and promoter to be working together or be the one and of the same. So the one other thing that comes up in this so the one other thing that comes up in this lawsuit is the alleged interference by the promoter Greg Cohen in relation to Miljas trying to get a future representation after Miljas terminated his relationship with Greg Cohen Promotions. So there was evidence in the record that Miljas was trying to get a promoter, I believe Queensberry Promotions, to represent him, but they had backed off because of the potential lawsuit Cohen would file, because Cohen had claimed that he was still representing Miljas. Now, in the motion brought by Cohen, he argues that he believed he had a valid contract and had a right to assert the fact that he had a valid contract with a boxer, and therefore there is no actual interference with a potential business contract or contact, because there was a valid reason for him to not interfere but to become involved. Miljas, on the other hand, argued that in fact he had a possibility to find another promoter to help him, and could not work with that other promoter because, of course, he was blocked by Cohen, because the other promotion did not want to get sued by Cohen and potentially get held up in something that they did not want to be a part of. So where does this go from here? Now, both of the parties have filed their papers in the post-trial briefing related to the motion for judgment as a matter of law. We should be hearing something sooner than later as to what's going to happen. If the court denies Greg Cohen's post-trial request for a judgment as a matter of law, basically asking for an overturn of the jury verdict as well as a new trial. If the judge denies that from actually happening, then we could see an appeal happening. And the appeal would be more of a prolonged process, also more costly process, simply because Cohen would have to post a bond, and that would be pretty hefty. But of course, the verdict is I believe, $1.5 million in excess of that, and plus attorneys' costs and fees, which is nearing, I believe, over $200,000. So we were talking almost about $2 million that Cohen is out if he loses this lawsuit and does not win on an appeal. So that's where we're at this point. We'll keep following this lawsuit. It's a very interesting one for those of us that have followed the Ali Act, and how we haven't really seen a lawsuit in which a boxer prevails utilizing the Ali Act, and we might not if Greg Cohen gets his way in the post-trial briefing requesting to overturn this jury verdict. So we shall see. It's Jason Cruz once again. It's the legal submission, y'all. MMApayout.com. We'll talk to you soon. Bye-bye.